You'll all, I think, get asked if you're happy for this to be recorded, and obviously you're welcome to accept or decline, but I think if you decline, it will be, you'll get kicked out, I'm afraid. You are very welcome to leave your videos on or have them off, entirely up to you. We do have you all muted, and we have removed your ability to unmute for the time being. It just means that we don't get background noise and stuff when we're speaking. So hopefully we should have a smooth event with nobody gate crashing or doing anything they shouldn't be. Danielle, yes, this is being recorded, and you will get a link, or you can check into our branch YouTube channel and have a look there for past events, and this one will be posted there as well. So yes, I know we're going up in the world, having a branch YouTube channel, which is very difficult to say, actually. All right, so I think we let everyone know there's some people in the waiting room. So let me just let these in for the waiting room. Bang on 4. Once these guys are in, we'll get cracking. Obviously, I think everyone's familiar with the controls for Zoom. You've got the chat box that you can all use if you want to make any comments or anything during the course of the presentation. And you've got the reactions, the ability to put thumbs up or thumbs down or whatever as well. So please do use those. We will be monitoring the chat box as we go. Are we doing questions at the end?
Yeah, I think so. All right.
Fantastic. So Victoria, there is me speaking. So if you can't hear anything, I'd just check your speakers, which may or may not resolve the problem, or either possibly sign out and go back in again. Might be the plan if that doesn't sort. All right, and we'll get started. So for those who don't know me, my name is Julie Temple, and I am the co-chair of the CIPD Essex and Ipswich branch. I am appearing today unusually in that capacity because, as I'm sure many of you will know, I'm also the head of employment at Birkett Long. But today I'm very pleased to say that I'm joined by Helena and Rianna, both solicitors in the team here at Birkett Long, and they're going to be guiding you through today's virtual employment law and HR update. And I'm hoping to simply sit back and enjoy what they have to say today. So without further ado, I'm going to pass straight across. I'm not sure who's going first. Is it Rianna? You're going to introduce
It's me,
things?
yes.
Perfect. So over to Rianna.
Fabulous. Thank you, Julie. Thank you, everyone, for joining us this afternoon. So we'll run through the agenda, what we're going to speak about in today's update. Firstly, we're going to give you some employment law updates, as the name suggests, and then the bulk of the update will focus on case law. So Helena and I have both picked some cases which we think are interesting, and we're picking out the salient points from them, any learning that we can take, and what's relevant for employers and HR professionals. So as I said, updates first. We'll then talk a little bit about P&O Ferries, which has been a very topical issue. I'm sure you've seen and heard about that in the news. Case about grievances, vicarious liability, flexible working, and we'll finish off speaking about restrictive covenants before we open up for any questions at the end. So just some updates to be aware of first. This happened at the beginning of the month. You may be aware of it already, but if you aren't, minimum wage increased from the 1st of April. Just to draw a distinction between national living wage and national minimum wage, when we talk about national living wage, that's for employees and workers who are aged 23 and over, and national minimum wage is for employees and workers aged under 23. So you can see there, national living wage is increasing to £9.50, National minimum wage for employees between 21 and 22 is increasing to £9.18. Between the ages of 18 and 20, the increase is to £6.83. For under 18s, the increase is to £4.81, and it's the same for apprentices. We will send you some notes at the end or following the presentation, and this table will be in it along with the other rates and limit increases. We're not going to be able to speak about them all today because we'd be here for a while, but we're just giving you the most salient ones that we think you should be aware of. And I'm also just going to give a little explanation about how to apply these rates. I'm conscious that sometimes we just say there's been rate increases and we leave it at that. But the higher rate, the higher payment rate, will start to apply from the next pay reference period after the increase, if you're not aware. And a pay reference period is dependent on how often the employee or worker is paid. So if an individual is paid daily, the pay reference period is 1 day. If they're paid weekly, the pay reference period is 1 week. And you guessed it, if they're paid monthly, the pay reference period is 1 month. And we have included a worked example in the notes that we will be sending out for you. But essentially, I'll just run through it quickly to put it into practice. So there's a minimum wage increase on the 1st of April, and we'll take Sam as an example. He gets paid monthly on the 15th of every month. The old rate will apply until Sam's next pay reference period, which will start on the 16th of the month. So as a minimum, Sam should get the old rate for the 1st of April to the 15th of April and the new rate from the 16th of April onwards. If you haven't followed that, that's fine. As I said, it's in the notes, but I just thought sometimes we only give the figures and we don't really say how to apply them. So hopefully that is helpful. Some more rates and limits to be aware of. These on the screen change from the 6th of April. To be aware of is that week's pay will now be capped at £571. It was originally £544, and that's relevant for calculating the basic award and redundancy payments. The maximum compensatory award for unfair dismissal will be capped at £93,878. And the minimum basic award for certain unfair dismissals, which include health and safety dismissals, has increased to £6,959. And you can see the final bullet point makes it clear that these figures and rates are applicable to dismissals that occurred on or after the 6th of April, so from now. There are more, as I said, rates and limits, and Birkett Long have provided a rates and limits sheet, which we update every year. So what we'll do is we will send that along with the notes as well. It's quite a useful tool, and it details all the rates and limits that have changed and the changes that have taken place in April. So that was just my quick update. Pass to Helena now to speak a little bit about COVID.
Thank you, Rianna, and welcome everybody. So it's likely you already have policies and procedures in place post the removal of the final government restrictions, one of the key ones being the end of the legal requirement to self-isolate if testing positive for COVID, which was the 24th of February. But I do feel it'd be remiss if we didn't cover the latest guidance that did come out on the 1st of April. So this may just be a reassurance exercise for many of you who are already up to date, but I may touch upon something that you may wish to consider further. So the first bit of guidance that came out was on the 21st of February, entitled COVID-19 Response, Living with COVID-19. Some key points from that were listed under business and other organisations, and it detailed that the intention is to empower businesses to take responsibility for implementing mitigations that are appropriate for their circumstances. So as at the 24th of February, workers were no longer legally obliged to tell their employers when they were testing positive for COVID and needed to isolate. As at the 1st of April, the government removed the health and safety requirement for every employer to explicitly consider COVID-19 in their risk assessments. Also, as at the 1st of April, the government replaced the existing set of working safely guidance with new public health guidance, which is the second piece of guidance that is detailed on the slide here. So that was published, as I say, on the 1st of April, entitled Reducing the Spread of Respiratory Infections, including COVID-19, in the Workplace. So while there is no longer a requirement for all employers to explicitly consider COVID-19 in their health and safety risk assessments, it is important that employers continue to comply with their legal obligations relating to health and safety, employment and equality duties. So there were a few key points from that guidance that I'd just like to raise with you now. So one being that employers are encouraged to know the symptoms. And there will be a link to that guidance in the notes that will follow, and it does list the symptoms that they suggest being aware of there. And it's just important for employers and for your staff to be aware of the symptoms so that you can take actions to reduce the spread as and when that happens. A second point is knowing what to do if a member of staff has symptoms. And if they're unwell with the symptoms, there is guidance, a separate piece of guidance, again, a link to that will be in the notes, and employers are encouraged to consider how best to support and enable their workforce to follow that guidance. Another step is actions to reduce the spread, and in the guidance it provides a number of examples of how you can do this. So one being encouraging and enabling your workforce to have their vaccines, so considering how best to support and enable staff who wish to be vaccinated to get their vaccines, which I'm sure you've already been doing. We've been discussing giving people time off if they need to have their boosters, whether that's going to be paid or unpaid, and just supporting them, considering some people become unwell after having a booster. So just taking all of those things into account. A second thing is letting in fresh air. So just bringing in fresh air to occupied spaces can help to reduce the concentration of respiratory particles, and this lowers the risk of airborne transmission of viruses. So the Health and Safety Executive has produced some guidance on how to assess and improve ventilation in line with health and safety requirements under Workplace Health, Safety and Welfare Regulations 1992. And there is detailed COVID-19 specific guidance for workplaces, and that's provided by the Chartered Institute of Building Services Engineers, and that's for those who wish to put in additional measures. Another point, maintaining a clean workspace. So keeping workspaces clean sounds an obvious one, but it's something that potentially could be easily forgotten, does reduce the risk of infection and reduce sickness in the workplace. And it's especially important to consider spaces where there's a lot of people touch those areas. And the final point to consider from that guidance is outbreaks in the workplace. So if your company experiences high levels of people with symptoms in the workplace, the actions that I've just mentioned, so letting in fresh air, making sure workplaces are clean, those should be promoted and applied very rigorously. Two further points from the guidance: management of members of staff who are at high risk of serious illness from COVID-19. So there is specific guidance for those with immune system issues and those that are at higher risk, and employers are encouraged to consider the needs of those employees who are at a greater risk of COVID-19. And last but not least is risk assessments. So employers may choose to continue to consider COVID-19 in their risk assessments, and it would be sensible to consult with your employees whilst doing so. A couple of key questions to consider, and if you've already considered these, perhaps to reflect upon what your answers are already. So now that free testing is no longer available, if you require testing, will you be providing free tests to employees? And if so, in what circumstances? What arrangements have you put in place for employees showing symptoms? If employees test positive for COVID-19 but are well enough to work, will you require them to stay away from the workplace, or would they be able to work from home? And where employees are unable to work from home and your policy requires them to stay away from the workplace, what are your pay arrangements for those employees? A final question: what arrangements have you put in place for those that are at higher risk? So those are just a couple of points to consider from the guidance, and I'll be passing you back to Rianna.
Thank you, Helena. So now we'll be moving on to our sort of case law section, which we're going to focus on the majority of the presentation on. I'm going to talk firstly about P&O Ferries, so not case law as such, but a very kind of topical issue that has had extensive media coverage. I'm sure you will all have come across it. It's died down a little bit now, but certainly when P&O's actions came to light, it was subject to a lot of media scrutiny. If you aren't aware, though, I'll just run through the background. On Thursday, the 17th of March, P&O Ferries sacked 800 members of their crew on grounds of redundancy by way of a video message in what they said was a very difficult but necessary decision to secure the viability of the business. It was then conceded a few days later on the 24th of March by P&O's boss, named Peter Heatherthwaite, that no consultation was carried out and that the video message was the only notice that was received by the employees. He said that this decision was taken because the company considered it had no alternative to continue trading and that no union would have accepted the changes that were planned. So the actions that P&O Ferries taken have brought redundancy and consultation processes into the spotlight, and you can take what they did as a good sort of do not do this, essentially, what not to do when making staff redundant. And I think because of the issues that it has brought to light and because of they did things so wrong, it's worth revisiting the general principles on redundancy and consultation processes just quickly, because it was such a topical issue, and it was an issue which the actions that they took did anger and upset a lot of people. So as a reminder, a genuine redundancy situation is one where an employer has a real business reason to justify dismissals, such as a business closure, a workplace closure, or a reduced requirement for employees. When contemplating making potential redundancies, employers should be mindful of the following, and I've popped these on screen. Where 20 or more redundancies are proposed at one establishment within a 90-day period, an employer is obliged to carry out collective consultation with appropriate representatives for a period of at least 30 or 45 days, depending on how many redundancies are proposed. Employers are also obliged to notify the Department for Business, Energy and Industrial Strategy of the proposed redundancies by submitting a HR1 form at least 30 or 45 days before the first dismissal. Employers should be carrying out a fair selection process and individual consultations with those provisionally selected for redundancy. And for any employee ultimately made redundant, an employer will be obliged to provide them with their minimum notice periods and redundancy pay entitlements. Now, failure to follow these steps could lead to claims being brought against an employer, such as protective awards for failure to collectively consult and unfair dismissal if the employee has the requisite period of service. Now, we've heard from P&O themselves that they'll be compensating those that they made redundant, and they said they're going to be offering enhanced payments, and one can assume that's to minimise the risk of claims being brought in the tribunal, but it remains to be seen whether any claims will go on to be brought, and we'll have to watch this space. But it's certainly sent shockwaves through government, and people have been quite outraged at the way the P&O staff were treated. So that was just a quick recap of redundancy and consultation processes. Another issue that P&O's actions have brought to light and into the focus is fire and rehire practices. Now, I should say that the situation with P&O Ferries doesn't appear to be a fire and rehire situation in the usual sense, because when we talk about fire and rehire, we usually use that terminology to describe the practice where an employee's contract of employment is terminated, and then that same employee is immediately re-employed by the same employer, but on new terms and conditions of employment. And it's a way of circumventing agreement, essentially. I think it had been said in the news, though, or a government minister may have said this, but P&O's actions were just a fire situation. they made their employees redundant, and then they brought in new workers on a low paid wage. They didn't re-engage the same employees, but it still brought the topic of fire and rehire to the forefront. So it's worth mentioning, because it is a controversial tactic, and there have been calls previous to P&O's actions for legislation to combat it. I think Tesco were trying to do something with it, and British Gas have also fallen foul of using this tactic. So there were calls for legislation to combat it, but ultimately the government decided that legislation was not the answer, and instead called upon ACAS to provide guidance. They said they needed to put something forward so employers who are considering using these tactics have some guidelines to follow, essentially. And ACAS did produce this guidance in November 2021. And within it, they made clear that fire and rehire should be an option of last resort, and that employers should have made all reasonable attempts to reach agreement first through full consultation before resorting to such measures. P&O, though, still went ahead and did what they did. So the government have taken the view that further guidance is necessary. And on the 29th of March, in Parliament, the Labour Markets Minister, Paul Scully, announced that there would be a new statutory code on the practice of fire and rehire in light of P&O's actions, as it recognised that, something still needs to be done about this. So Mr. Scully said that the code will clamp down on controversial tactics used by unscrupulous employers who fail to engage in meaningful consultations with employees. This new statutory code will detail how businesses must hold fair, transparent and meaningful consultations on proposed changes to employment terms. And it's hoped that the code will clarify and give some legal force to the government's expectations that employers should behave fairly and reasonably when seeking to change employees' terms and conditions. It's hoped the code will act as a deterrent, particularly to those employers seeking to use the threat of fire and rehire as a negotiation tactic. And most importantly for employers and employment lawyers and HR professionals, is that the employment tribunals will be able to take this new code into account, and they will apply an uplift of up to 25% of compensation if they find that an employer has unreasonably failed to comply with this code, much like they do now with the Code of Disciplinary and Grievance Procedures. So there's no date for when the code is going to be published, it's going to be announced yet. But as I said, this is something that the government has focused on. So we're likely to see it soon. And if so, we'll provide an update as and when accordingly. But that was what I wanted to say on P&O Ferries. I'll pass back to Helena now.
Many thanks, Rianna. Right, so we've seen an influx in grievances recently when speaking with our clients, and many of you joining may be experiencing something similar. So I thought a case on grievances would be a good topic for us to cover today. Employers often have to manage situations where employees raise multiple grievances or complaints, and sometimes that is a tactical move, perhaps to delay a disciplinary process. But that can be very difficult for employers to deal with. And sometimes we're asked, are we able to treat this, the raising of a number of complaints, as a disciplinary and perhaps dismiss fairly on those grounds, on the grounds of conduct? And in this case, Hope and British Medical Association, the Employment Appeal Tribunal considered just that. So the question on the slide right now, I'd like to pose to you all. And if you think yes or no to this, if you could type in the chat box. But the question is, can an employer fairly dismiss an employee who raises multiple frivolous or vexatious grievances? So if you think an employer could dismiss fairly, could you type yes in the chat box? If you think that's likely to be an unfair dismissal, could you type no in the chat box? And we would like to see the consensus there. So I'll just give you a minute, but lots of yeses. Not seeing one no. Everyone's feeling pretty brave and not so risk averse today. Yes, but needs to be reviewed before making the decision. It's a very balanced answer. Okay, so overwhelmingly a yes for that. I won't reveal the answer just yet. I shall take you through the background of the case and then I shall reveal the answer at the end of that. So the background to this case, so the claimant, Mr. Hope, was employed as a senior policy advisor by the respondent, the British Medical Association. He brought a number of grievances against senior management and multiple grievances about not being invited to certain meetings. The claimant wanted these grievances to be dealt with informally with his line manager, but unfortunately those informal discussions did not resolve the issues. So the employer tried to deal with this on a formal level, but the claimant refused to progress to any formal stage, but also refused to withdraw the grievances. So this obviously left the employer in a bit of a limbo state. The claimant was warned that he could face disciplinary action if his grievances were found to be frivolous or vexatious. In response to that, he raised another grievance. And by this stage, there are around 7 grievances raised by this one employee. The employer arranged a grievance meeting and made it clear to the claimant that his attendance was a reasonable management instruction. The claimant refused to attend the meeting, so the meeting took place in his absence. And the claimant's grievance was dismissed, and the employer found that his conduct was frivolous, vexatious, and an abusive process. And as a result, a disciplinary process was invoked. And the allegations against the claimant were: 1, that he submitted a number of frivolous grievances; 2, that he failed to follow a reasonable management instruction; and 3, that there was just a fundamental breakdown in the working relationship between this individual and the employer. So following the disciplinary hearing, the employee was dismissed and he brought a claim of unfair dismissal in the employment tribunal. Could we please move to the next slide? Perfect, thank you. So at tribunal, the respondent carried out a reasonable, well, the tribunal decided that the respondent had carried out a reasonable investigation and disciplinary procedure, and that it was not unreasonable for the respondent to conclude that the claimant's conduct was vexatious and unreasonable, and the tribunal said that it was within the band of reasonable responses to treat his conduct as a sufficient reason for dismissal. The claimant appealed that decision to the Employment Appeal Tribunal on 2 grounds. 1, that the tribunal wrongly concluded that his conduct met the definition of gross misconduct as something that either involves deliberate wrongdoing or gross negligence. And the second ground was that the tribunal's findings were perverse. The EAT dismissed his appeal, and the EAT said the starting point for them was considering that gross misconduct point, and referred us to Section 98 of the Employment Rights Act 1996. And that section refers to conduct as being a permissible reason for dismissal rather than misconduct, whether that was gross or otherwise. And whether dismissal by reason of conduct was fair or unfair really depended not on the label or the characterisation of the conduct as gross misconduct, but on whether, in the circumstances, including the employer's size and administrative resources, the employer had acted reasonably in treating the conduct as a sufficient reason to dismiss that employee. So I think generally for all of us, when we consider gross misconduct, that meaning is the most serious type of misconduct that warrants instant dismissal without notice. And it was described in the case of Neary and Dean of Westminster as conduct that so undermines the relationship of trust and confidence that the employer should no longer be required to retain the employee in his employment. So when considering this, the Employment Appeal Tribunal confirmed that the following 4-stage test should be applied, which is on the screen now. So step 1, did the employer hold a reasonable belief that the claimant was guilty of misconduct? 2, was the belief based on reasonable grounds? 3, were the reasonable grounds formed on the basis of a fair and reasonable investigation? And 4, did the claimant's dismissal fall within the range of reasonable responses? The EAT said that it was not necessary for the respondent to demonstrate the claimant had willfully committed a breach of contract, or alternatively that he had committed gross misconduct in order to find that that he had committed an act of gross misconduct. And also the Employment Appeal Tribunal rejected the claimant's perversity arguments. The reason for the dismissal had not been that he hadn't attended the meeting. That was just one of several reasons put forward by the respondent. The EAT also noted that the purpose of a grievance procedure is to resolve concerns about colleagues or the workplace, and it was not for complaints to be left unresolved or capable of being resurrected at any time. And the EAT recognised that employers are not expected to leave concerns unresolved for an unlimited period, which could destroy the ability to address legitimate concerns properly. And actually the focus is on the well-being of the individual that has brought the grievance and also the individuals that are the subject of that. And the EAT said, look, it was clearly permissible for the original tribunal in this case to consider that the respondent had acted within the range of reasonable responses. So the short answer to that question is yes, an employer can fairly dismiss an employee who raises multiple frivolous and vexatious grievances. So well done everybody, majority correct on that one. So just a few key points to take away from that case. So the decision does provide some level of comfort for employers that employees that take advantage of the process there's a possibility that they could be disciplined or that they could be dismissed fairly. But of course, that's very case specific and we can't apply a blanket test here. It will have to be considered on each grievance as necessary. The second point being, therefore, that employers should tread carefully. Taking a decision to discipline or dismiss an employee in connection with raising concerns could very well lead to a case, and cases could be brought, for example, not limited to just these, for unfair or constructive unfair dismissal, whistleblowing, discrimination, and or victimisation. So just to tread very carefully there. The third point is clear communication is really key. So in this case, the fact that the respondent clearly warned the claimant that his conduct in raising those complaints could be viewed as vexatious or an abusive process, together with making it very clear that if he failed to attend that meeting, there would be consequences because it was a reasonable management instruction. And the respondent having made those points very clear to the claimant at the relevant time really helped their position and made the dismissal legitimate because of that clear communication. So just want to make that clear. And the final point is, if you're dealing with multiple grievances and multiple complaints, you are entitled to consider, is this something we've considered in the previous grievance, or are a number of grievances actually connected and arguably we can deal with them all at once, just to have a think about your resources and time. And yes, that's my points in the end of the grievances section for me. So I'll pass back to Rianna to discuss her first case with you.
Super, thank you, Helena. So the case I'll be looking at is Chell and Tarmac Cement and Lime Limited. And as I mentioned when speaking about the agenda, this is a case about vicarious liability. And although it's not an employment tribunal case, it is relevant for employers, as in common law, an employer can be found to be vicariously liable for the tortious acts of its employees if they're carried out in the course of employment. It doesn't matter if the employer itself has committed no wrong. If there's a sufficient connection between the wrong and the employee's employment, then it may be fair to hold the employer to be vicariously liable. Whether vicarious liability arises involves a two-stage test. The first limb of the test asks, is there a relationship between the primary wrongdoer and the person alleged to be liable, which is capable of giving rise to vicarious liability? And the second limb of the test asks, is the wrongful conduct so closely connected with the acts the primary wrongdoer was authorised to do, or the role or field of activities entrusted to the wrongdoer, that for the purposes of the liability of the employer, it may be fairly and properly regarded as done by the employee whilst acting in the ordinary course of their employment. To answer these questions and to fulfill the test, identification of the nature of the wrongdoer's job or field of activities, or what they were authorised to do, is required, and also an evaluation between whether there is a sufficient connection. Both limbs of the test must be satisfied for vicarious liability to be found. And I'd like you to just keep that in mind. Sorry, skip forward too far. I'd like you to keep that in mind as I speak on the facts of the case. So the facts of this case were that Mr. Chell, the claimant, was employed by a company called Rolltech and worked as a contracting fitter for Tarmac, who are the respondent. Tarmac also directly employed its own fitters, and because of this, tension arose between the contracted fitters and those employed by Tarmac directly. One of Tarmac's own fitters, named Mr. Heath, as a practical joke, not very funny, but this is what he did, detonated 2 explosive pellets close to Mr. Chell, which sadly resulted in a perforated right eardrum, noise-induced hearing loss, and tinnitus. As a result of his actions, Mr. Heath was dismissed by Tarmac. Due to his injuries, Mr. Chell brought a negligence claim directly against Tarmac, and also against Tarmac as being vicariously liable for the actions of Mr. Heath. Tarmac denied that the actions of Mr. Heath were within the course of his employment, saying that horseplay is not part of an individual's employment. And it went on to deny any liability for Mr. Heath's actions, which it said were wholly outside the scope of any reasonable foreseeability, risk assessment, health and safety guidelines, or his employment, but were actions of his own volition without any sufficient connection to make his employment to Tarmac liable. The county court agreed with Tarmac and Mr. Chell appealed. So the matter went to the High Court and it was dismissed. The judge prefaced his judgment by saying that the practical joke must be the lowest form of humour because it's seldom funny and it's often a form of bullying, and it has the capacity, as in the present case, to go seriously wrong. On the vicarious liability issue, the High Court revisited the 2-limb test and said there's 2 questions to be asked here, that being, what are the functions or fields of activities that had been entrusted by the employer to the employee? And was there a sufficient connection between the position in which the employee was employed and the wrongful conduct to make it right for the employer to be held liable? Well, the High Court held that the County Court had correctly applied the law in finding that Tarmac could not on this basis be found vicariously liable for Mr. Heath's actions. And on the direct breach of duty issue, the High Court endorsed the comments of the County Court, and they said that horseplay, ill discipline and malice are not matters that would be expected to be included within a risk assessment. Tarmac was an employer which took its health and safety responsibilities seriously, and in that context, it was expecting too much of them to devise and implement a policy or site rules which descended to the level of horseplay or playing practical jokes. So the High Court found that the County Court was entitled to conclude that the existing site health and safety procedures, which included a section on general conduct, stating that no one shall intentionally or recklessly misuse any equipment, was sufficient given the many ways in which employees could engage in horseplay, ill discipline or malice, and nothing more specific could reasonably be expected. And also that increased supervision to prevent horseplay, ill discipline or malice was not a reasonable step to expect this employer to have identified and taken. So Mr. Chell appealed and the matter went to the Court of Appeal, where it was dismissed again. The Court of Appeal held that there was an insufficient connection between the employer-employee relationship and the prank, so to find the employer not vicariously liable for the individual's actions. And Lady Justice Nicola Davies presiding stated that the risk created by this employee was not inherent in the business, and on no basis could it be said that the employee was authorised to do what he did by tarmac, nor were his actions an unlawful mode of doing an authorised act. And further, she held that it would be unreasonable and unrealistic to expect an employer to have in place a system to ensure that their employees did not engage in horseplay. So what can we take away from these decisions? Well, the Court of Appeal decision will give comfort to employers it's held that if the actions of an employee are not connected to the activities that they're employed to do, that means it's unlikely the employer will be found liable for any harm suffered as a result of them. And additionally, where those actions are committed during the course of an employee's employment, but it's not reasonable for that kind of action to have been taken into account in a risk assessment, then the claim may fail. And there have been quite a few cases recently on vicarious liability, and the decisions within them have made it clear that the courts are taking a hard line on what liability an employer has for the actions of its employees and its contractors. And it's not enough to say that they were given the opportunity to carry out these actions because of their employment. However, a word of warning, because cases such as these do remain very fact sensitive and difficult to assess, and a relatively minor shift in the circumstances could have been material. So if we take, for example, had the pellet targets that Mr. Heath detonated been supplied by Tarmac, they weren't, but had they been, or had Mr. Heath been required to hammer them as part of his job, or work alongside Mr. Chell in the workshop, any of these points may have been sufficient to deliver a different result in this case. So do bear that in mind. And also would just emphasise that this decision should not be seen as lessening an employer's duty of care to protect the health and safety of its employees, its contractors, and any third parties who may visit the workplace. It's still really important that employers are fully aware of their health and safety responsibilities and ensure that procedures are fully up to date, and that includes risk assessments as well. So that was Chell and Tarmac. Back to Helena now for her second case.
That's great, thanks Rianna. So another topical subject area is flexible working. So again, we've seen an increase in flexible working requests, which we've anticipated and will have discussed in previous webinars following the return to the workplace. It's understandable and natural that there were going to be a number of flexible working requests coming in as people had to change their routines again. So a couple of general points about flexible working. The statutory scheme for flexible working requests is set out in Part 8A of the Employment Rights Act 1996 and the Flexible Working Regulations 2014. There's also an ACAS code of practice that provides guidance that's also very useful. All employees with at least 26 weeks continuous employment are able to make a statutory request for flexible working in writing and for any reason. Only one request can be made every 12 months. Where a statutory request is made, the employer must deal with that request in a reasonable manner and must notify the employee of the outcome, including any appeal, within this 3-month decision period. And that period begins with the date that the employee's request was made, unless the time frame is extended by mutual agreement. If the employer wishes to reject that statutory request, it can do so on one of 8 grounds, which are 1, the burden of additional costs, 2, inability to reorganise work among existing staff, 3, the inability to recruit additional staff, 4, detrimental impact on quality, 5, detrimental impact on performance, 6, detrimental effect on the ability to meet customer demand. 7, insufficient work for the periods the employee proposes to work. And number 8 is a planned structural change to the business. The government did have a consultation on this, which closed in December 2021, as to whether all employees should actually have the right to request flexible working as a day one right, and we await the outcome of that. And of course, as soon as we know, we will make sure that we update everybody. So I will be looking at the case of Walsh and Network Rail Infrastructure, which considered what constitutes an agreed extension to that 3-month time limit to consider a flexible working request. An employee may bring a tribunal claim for a breach of the statutory scheme on a number of grounds, and the key one here being that the process did not conclude within the decision period. A couple of other grounds that are relevant to this case are that the employer failed to deal with the application in a reasonable manner, and also that the rejection of the application was based on incorrect facts. A claim cannot be brought until either the employer has notified the employee of its decision or the decision period, including any extension, has ended. And the amount of any award of compensation shall be the amount the tribunal considers just and equitable, but will not be any more than 8 weeks' pay for any particular individual. So that's some general points on flexible working. I'm now going to ask you a second question, which is on the screen. And again, if you think the answer is yes, please type yes into the chat box. And if a no, please type a no into the chat box. So the question is an agreement to attend an appeal hearing made after the expiration of the decision period an implied agreement to extend that decision period? So let's see what you think to that question. So we got no so far. Mostly no's, a couple of yeses. Yes. This is an interesting one because I did ask a few colleagues about this, and I did get a mixed response to just the general question without any background. So I think I wouldn't judge anybody either way on this one, but it's majority no. We have a few yeses in there, and we shall, okay, I'll leave it at that. So I think we could say majority no, a few yeses. I shall explain the case and a bit of the background, and then I will give you the answer. Okay, so on the 11th of February 2019, Mr. Walsh submitted a flexible working application. Network Rail rejected the application on the 7th of March, and Mr. Walsh appealed on the 13th of March. Over a period of time, there was extensive correspondence between the parties seeking to fix a date to hold the appeal hearing. But during that time, the decision period actually ended on the 10th of May. The claimant applied to ACAS on the 4th of April, and an early conciliation certificate was provided the same day. On the 24th of June, so of course we're outside of that decision period time now, Network Rail confirmed that the appeal would take place on the 1st of July, and Mr. Walsh agreed to attend that appeal. On the 25th of June, so the day after he had been informed that the appeal would take place on the 1st of July, Mr. Walsh presented his tribunal claim. And the 1st of July came around, they held the appeal, and Mr. Walsh's appeal was rejected. Obviously, in the background of this, the tribunal claim had been put in and was going through the processes. So the tribunal actually heard the case, but the tribunal held that it did not have jurisdiction to hear the claim when reviewing it, because the agreement to hold Mr. Walsh's appeal on the 1st of July necessarily involved an agreement to extend the decision period. So the tribunal decided that yes was the initial answer to this question, and that the claimant's agreement to attend the appeal hearing did actually extend the decision period. But Mr. Walsh appealed to the Employment Appeal Tribunal. Next slide, please. Thank you very much. So the EAT held that the tribunal actually did have jurisdiction to hear that claim, and that the statutory scheme is clear that there must be an agreement to extend the decision period, and that an agreement to an appeal on a specific date did not necessarily involve an agreement to extend the decision period. The specific agreement to the period of the extension is needed to avoid confusion on whether the agreement is to the appeal date or for a further period for an appeal to be determined. And there is a quote here that I've put on the screen from the judge of that hearing, which was James Taylor, who said that there is nothing implicit in an employee agreeing to attend an appeal hearing that means that the employee must have agreed to an extension of the decision period. An agreement to attend an appeal after the expiry of the decision period is no more than that. For the decision period to be extended, there must be an agreement for an extension. Next slide, please. So the short answer to that initial question is no. An agreement to attend a meeting outside of the initial period does not automatically extend that deadline. There has to be a separate agreement to the deadline. I think on the face of it, it's not necessarily so straightforward, and you could see how arguably if your employer, you might feel a bit relieved if the individual has agreed to attend an appeal hearing, and you might think that logically that would extend it, but this case confirms that it doesn't, and it's really important to separately obtain that agreement. So there's a couple of points that I wanted to mention that are takeaways, and the first one being there is a 3-month deadline, and it's really important to get that review of the flexible working request done in that time. So put a note in your diary that the 3 months is coming up, put a few reminders in there, and just try to make sure that you get the decision and the appeal to the employee within that time frame, so you can avoid dealing with this kind of query altogether. My second point is that if actually you are in a situation where you feel like we need an extension here, make sure that you get an agreement with the employee to the extension within the original time period. And I would recommend getting that in writing and keeping it somewhere safe. And the third point is about considering your policy. Review your policy. Is it up to date, and is it fit for purpose for your organisation? And a few points that reading the case, I found interesting and thought would be worthy of note to you now, is one, that there is no requirement for a hearing or to have an appeal. That's not part of the statutory scheme. It's something that obviously is recommended, or ACAS does suggest that it's good practice to allow an appeal, but it's not something that's necessary. So depending on what your policy says, you kind of, if it says it in your policy and you're in the middle of a process, you're kind of tied to it. But have a think about timing and whether you've actually got time to carry that out, and that might be something to consider in a policy review. The second point is where the employer's procedure does provide for a hearing, and this was something that was mentioned in the case, if the employee fails to attend 2 hearings in a row, then that could result in the application being treated as having been withdrawn. But again, that's really important. If you're going to argue that, it's really important that you've let the employee know in advance that that's a consequence. And I think that's a theme you can see throughout the cases we've discussed, that it's really important to let employees know upfront what the consequences will be of certain actions, and therefore you can then rely on that because you informed them in advance. And the final point I just wanted to mention was that the tribunal found in this case that failing to fix a date for the appeal was actually no fault of either party. It was just one of those situations where 3 months went past rather quickly. Both parties were attempting to get something in place. There was no foul play, but it just didn't happen. So that's something that could happen to any of us. So perhaps have a think about your policy. If it includes the option for an appeal, would it be appropriate perhaps to say in there that that is flexible with a view to the time you have, and perhaps to how reasonable the employee is with agreeing to an extension if that might be necessary. So just kind of giving yourself a little bit more space and breathing room there, because as we've said, as we always say, what you have in your policy is your guidance for you to follow, and it's for both sides to know what the procedure is. So if you give yourself a bit more breathing room there, you will allow an appeal, but it would be helpful if the employee is willing to agree to an extension so that you can consider that. That might be something that could have been a saving grace perhaps for the employer in this case. That's the end of the flexible working case review. I will pass back to Rianna to discuss her next case.
Thank you. Thank you. I don't know if I muted myself in time. Last case that we'll be considering is the case of Law by Design Limited and Saira Ali. This is a case about restrictive covenants, specifically non-compete clauses and their enforceability. So just a quick word on restrictive covenants before we dive into the facts of the case. But post-termination restrictive covenants are usually used because departing employees are often well placed to take advantage of confidential information, strategic plans, customer and client details, or other information about an employer's business after the termination of their employment. Employees may attempt to use this information for the benefit of their new employer or in order to set up a rival business, and this can seriously harm the former employer's business. Although employees must observe certain terms that are implied into every contract of employment, these are of a limited nature and they don't generally extend to the period after termination of the contract, except in relation to trade secrets. Express restrictions, on the other hand, and restrictive covenants that you may find in your employment contract can be specifically designed to reflect the party's circumstances. And if they're properly drafted and they're reasonable, they can limit the employee's conduct and prevent them from damaging the former employee's business. They may deter employees from joining competitors, and they might also deter potential new employers who face the risk that the restrictions will be enforced by the courts. So when deciding whether covenants are enforceable, the court must consider the doctrine of restraint of trade. And the starting point is that any contractual term restricting an employee's activities after termination is void for being in restraint of trade and contrary to public policy, unless an employer can show that, firstly, it has a legitimate proprietary interest that it is appropriate to protect, and the protection it's seeking is no more than reasonable, having regard to the interests of the parties and the public interest. So with that in mind, the facts of the case is that Saira Ali was an experienced employment lawyer who worked for Law by Design Limited, who I'll refer to as LBD throughout. LBD was a niche practice based in Manchester, and in the main, it provided advice to clients within the healthcare sector, particularly specific NHS entities in the northwest of England and one in Hertfordshire. The majority of Miss Ali's time was in the provision of employment advice to those entities, and she had within her service agreement a 12-month non-compete covenant and also a 12-month non-compete covenant under the terms of a shareholder agreement, which she signed when she was allocated minority shares in LBD. The non-compete covenant in her service agreement prevented Miss Ali from undertaking any work in competition with parts of LBD in which she had been materially involved in the 12 months preceding the termination of her employment. And the covenant applied across the northwest of England for 12 months. The covenant in the shareholders agreement was slightly different, however. That prevented her from being engaged, concerned, or interested in, or assist a business which competes directly or indirectly with a business of the company in a territory in which the company has operated in the previous 12 months. So effectively, this clause sought to prevent Miss Ali from working in England and Wales in relation to any business LBD was involved in. Now, Miss Ali went on to resign from LBD even, and joined Waitmans, or wanted to join Waitmans, which is a national law firm. And what she did is, in preparation and during her interview, she prepared a business plan for Waitmans, in which she said she could transition clients generating around £250,000 a year, which was more than a third of LBD's turnover, from LBD. She was going to try and poach them, essentially. As a result, LBD caught wind of this, and they brought a claim against her for enforcement of the covenants. The High Court found that the non-compete covenant in the service agreement was enforceable, but not the non-compete covenant in the shareholders agreement. And in coming to their decision, they applied a 4-stage test from TFS Derivatives Limited and Morgan, which required them to firstly decide what the covenant meant when properly construed. Secondly, to consider whether there's sufficient evidence of legitimate business interests requiring protection. Thirdly, to ensure that the covenant is no wider than is reasonably necessary. And lastly, to decide whether to exercise its discretion to grant an injunction to enforce the covenant. It found that the non-compete covenant in the service agreement was no wider than was reasonably necessary to protect LBD's legitimate business interests, but the non-compete covenant in the shareholders agreement failed the proportionality test and was void. This is because it prohibited competition with any other commercial business in England and Wales, and this included work Miss Ali was not involved in. This, of course, was held to be wider than was reasonably necessary for LDB to protect its legitimate business interests, as it did not have the specificity and limitation, i.e. to limit NHS employment clients in the northwest of England only, as the non-compete covenant in the service agreement did. So accordingly, the court granted an injunction in relation to the non-compete in the service agreement, but not the shareholders agreement. Now, this might be seen as a draconian decision for Miss Ali, and however, although a 12-month non-compete covenant may be harsh, it was very specific about the type of specialist work it covered and the geographical area concerned. The court accepted that LBD would need 12 months after Miss Ali's departure to re-establish its legal and commercial relationships with its NHS clients in that area. And of course, Miss Ali's case was not assisted by her business plan, which made it clear that her intention was to remove more than 30% of LBD's client base and fee income. So what can we take away from this case? Well, it reinforces good practice around drafting restrictive covenants. Non-compete clauses in particular can have a more drastic effect on departing employees than, say, non-solicitation and non-dealing clauses, and therefore they must be no wider than reasonably necessary to protect the employer's legitimate business interests. Employers should be carefully considering the scope of the restriction with regard to practice areas, location and duration, and limit the impact as far as possible. And regarding duration, this case seems to establish that depending on the circumstances, a carefully drafted 12-month non-compete covenant will be reasonable and will be upheld. But of course, the situation needs applying to a certain job, role, seniority, things like that. So it's always best to take advice on drafting. And also, if you're an employee and you want to check the enforceability of any covenant, it's best to get advice on that also. So that was the Law by Design case. Speaking about non-compete clauses, and I'd be very interested to hear any of your thoughts when we move on to the question, but it's a topic that the government has been considering as well, and they've actually run a consultation which closed on the 26th of February last year, seeking views on reforming post-termination non-compete clauses in employment contracts. It said that it was doing this to support the economic recovery from the impacts of COVID-19, to boost innovation, and to create conditions for new jobs and increase competition. The Department of Business, Energy and Industrial Strategy said that non-compete clauses can act as a barrier by preventing individuals from working for a competing business or from applying their entrepreneurial spirit to establish a competing business. And it's also observed that in certain jurisdictions where non-compete clauses aren't used at all, for example, tech startups, these industries have thrived without the need for the use of these clauses. So it's seriously considering whether there needs to be reform. The purpose of the consultation was to seek views on two proposals, and the two proposals that have been put forward is firstly whether non-compete clauses should only be enforceable when an employee provides compensation during the term of the clause. So around 60 to 80% of the employee's earnings would be paid whilst the clause is running, if you like. And actually, this is commonplace in many European countries already, such as Germany. Or the second proposal is just to simply make post-termination non-compete clauses in contracts of employment unenforceable altogether. Now, there's been no update on this yet, but at the beginning of March, Paul Scully confirmed that the response will be published in due course. So we're looking forward to seeing what the results of the responses were. And as like I said, I think when we move to questions, I'd be interested to hear anyone's thoughts on this, because, you know, you can see why non-compete clauses are useful, and perhaps you can also see how they can stagnate competition and business. So be interesting to hear about that. But that brings the end of our speaking part of the presentation. So we've got lots of time for questions, which is great. As we said, we'll be sending notes from today's session. We'll also I'll send the rates and limits sheet along as well, so you can have a look at that, and hopefully it'll be useful to you. Also, if you have time and if you'd like to, it would be great if you could complete a short survey. You can follow the link, and as I said, the link will be in the email as well. We'd be grateful for any feedback, good or bad, what you like, what don't you like, so we can tailor our presentations going forward. And with that being said, those are our contact details should you wish to contact us at all. But otherwise, we'll take questions. I think a few came in while we were speaking, and we'll see how far we get, and we will open the floor. I can see Julie's posted, yeah, so YouTube channel, the next event, and the survey in the chat box if you want to follow that. Just checking.
Rianna,
any questions?
Yeah, there's one question for you, Rianna,
Okay.
from Tribunal. So question for the end, back to P&O. It says, is it a true redundancy situation when the roles continue to exist, but they have changed the salary to under national minimum wage?
Yes, good question. I think that kind of hits the nail on the head, and it was something I considered as well. As I said, genuine redundancy situation has to be, you know, business closure, workplace closure, or reduction for the need of a number of employees. And that was not the case for P&O Ferries. I couldn't wrap my head around making employees redundant, but then just replacing them with completely new employees. I think, yes, it probably wouldn't be a genuine redundancy situation, and any employees with requisite service may well be entitled to bring an unfair dismissal claim. But I think P&O kind of foresaw that, and depending on the payments they're making, they may have circumvented the risk of claims being brought. If they've given enhanced payments, then you know, employees may not be able to go through the employment tribunal channels and recoup compensation. Of course, it's still open to them to apply to be reinstated, but that was exactly what I thought when it happened. It's not really a genuine redundancy situation, but I think they just took a line. They decided they were going to do this, and they committed to it, and just kind of are dealing with all the fallout now, which is very sad.
Yeah, I agree. I think sometimes in the non-employment law world, so for us, certain terms are used without the kind of legal definition. So perhaps it might have sounded less horrible to say you're being made redundant rather than you're being dismissed or your employment's being terminated. That's similarly, I'd say, with sometimes the words victimisation or harassment. There's kind of a general use of those words, but when it comes to employment law, they have very specific definitions and they're applied differently. So perhaps the word redundancy as opposed to termination or dismissal was a bit of a throwaway word that they use. But yes, as Rianna said, it's not a genuine redundancy situation if the jobs still exist.
I would, if I can, jump in there and just add, in the collective consultation world, redundancy carries a slightly different meaning in that it I need to try and remember the exact wording, but broadly speaking, it's where it doesn't relate to sort of the fault or the behaviour of the individual. So it does cover the traditional redundancy. It would cover the decision to fire and rehire, or potentially in this situation, and I must admit I haven't read a huge amount around the P&O situation, but I suspect their approach was, we're going to restructure the business, we're going to dismiss the existing staff, and we're going to bring on new staff at a lower rate of pay. And I think from the headlines, I can't remember whether it was this morning or yesterday, certainly reading the headlines, the suggestion is that they're going to have to pay the new staff the same rate as the old. So it's leaving aside the problems with the actual ferries leaving and carrying on as they were. I think it's obviously led to a little bit of a mess, to say the least. But yeah, I mean, there's sort of lots of learning, I think, in the P&O situation. All right, are there any more questions? What I might do is just open up people's mics, and then if anyone does want to jump in rather than type a question, if you want to, then take yourself off mute and just fire away. Obviously, if we get lots of people all wanting to speak at the same time, then we'll have to work out a different approach. But as you can see, some people having to leave, that's absolutely fine. Please do take a moment, if you wouldn't mind, just to fill in the survey. We are in the CIPD world in business planning mode, so we are looking at and thinking about events for the next year, which is academic years in CIPD world. So please do give us any thoughts, and also about whether there's any preference for virtual or face-to-face. I'm sure we all have our views based on our own circumstances, but we'd just like to get your views if we could. Really won't take you long. I would hazard a guess less than a minute to complete that, if you could, please. So I think there might be another one up there. Yes. From Jill, and I think that might be Rianna as well, isn't it?
Yeah, I'm pleased. Yeah, we've got an opinion on the restrictive covenants, which is nice to see. So thank you, Jill. Thanks to Peter as well, who said he's had to leave, understandably. So so Jill said on the restrictive covenants and their place in the world, I do think there is a place for restrictive covenant clauses, but they must take into account an employee's responsibilities, job role, status, etc. within an organisation. They should not be applied as a blanket clause in every employee's contract.
Yeah,
I feel like solid. We'd agree with that, wouldn't we?
Yeah, absolutely. I think that the absolute danger of applying a blanket clause is that it's not going to be applicable, not going to be enforceable for everyone. So that would not be a good approach at all. It is interesting that they're considering sort of doing away with them fully. And when I was researching this, I was having a little look at the Law Society and what their thought was on it. And they spoke quite... I thought that it was potentially a good idea to remove non-compete clauses because what it might do to open up competition and things like that. But what they did suggest was that maybe if employees are having non-compete clauses written into their contracts, that it becomes a requirement for them to receive independent legal advice, a bit like you do on a settlement agreement. So the employee knows from the outset whether it might be enforceable and knows the kind of limits of it. And then it was hoped, the Law Society said, at the end of the employment relationship, both the employee and the employer almost knew where they stood. And it kind of would give a bit more of an equal playing field, if you like, to kind of negotiate an exit. So I thought that was quite interesting. but we'll have to wait and see. I think with the government consultations, all we're sort of saying now is we'll update you when it happens, but there's a lot of consultations going on. So hopefully we'll start seeing them coming through soon, but it's just a wait and see really at the moment. But thank you, Jill, for your input. I think that's a good approach.
Yeah, I mean, I again can't help myself. Just reiterate that, I mean, I think there is a place for restrictions, but absolutely it has to be tailored. And I think sometimes what employers overlook, if there is those provisions in place, is actually reviewing them, changing them, tailoring them when individuals are promoted. Because the case law is very clear that it's considered the point in time at which the restrictions are put in place. And obviously, as individuals move along an organisation and move up, what may have been unenforceable at the start, on the basis that they've been promoted, might have become enforceable on the basis that they're more reasonable, more tailored towards the individual, but they're judged at the point the restrictions were put in place. So, it really is important that those things are reviewed, and it's a great practice anyway to obviously review contracts and review the terms, are they applicable, etc., as and when individuals move up. And I mean, we quite regularly advise on restrictive covenants, don't we? Either at the point of time at which individuals are offered a role and they're looking at whether the restrictions are fair and reasonable and enforceable, but also when individuals are leaving, either because they want to know if they can move on to the role that they've got lined up and whether the restrictions pose a threat, but also if the business is trying to impose new restrictions or reiterate the existing restrictions in settlement agreements. So, there's sort of lots of different points at which they can be reviewed, and there's always a bit of a balancing act as well in terms of the approach of the employee, because sometimes employees will stay quiet if they feel that the restrictions, or if the advice they get are the restrictions are unenforceable, because why should they volunteer to the employer that they're unenforceable? Equally, the employee can sometimes be, well, look, I just don't want the dispute, I don't want the headache, so let's try and agree what I'm happy to agree with and what I feel is reasonable. So I know, I'm on solid ground, so to speak. So there's kind of lots of balancing thoughts and things to think about there. But yeah, I mean, it'll be interesting to see what comes out of this consultation, and I mean, I think the idea of independent advice, the requirement for independent advice, I can see us ending up in a similar situation with settlement agreements where the employer has to foot the bill for that independent advice because the employee won't want it. Yeah. And of course, again, we'll be back in that situation where it's in the interest of the employer for the individual to get that advice, because otherwise the individual might be saying, well, I'm not going to agree to them, I'm not going to pay for that advice, therefore they don't go in. So it'll be interesting to see where we land. So have we had any other questions?
I don't think so. I just wanted to reiterate, everything that you just said, Julie, was so important. And I've got a couple of cases at the minute where it's been great. Individuals have stayed with a company for a number of years and built themselves up, and they're now looking to move on. And we're saying we haven't reviewed the contracts, and so they're now in this really important position and hold all of this information and know all our key contacts, but we don't have the restrictive covenant. So it's, as Julie said, it's so important when the person gets promoted, make it part of your HR processes. So have promotions being given, is this a level that we bring in restrictive covenants? I think it's just make it part of that process, because you just save yourself a headache, and we can try our best to help, but you're in a much weaker position trying to get somebody to agree something later when you've already given them the good news. So it's best to kind of give them the contract, and it's almost a compliment. You've reached a stage where you're getting some restrictive covenants. It's a bit of a compliment, but let's get that in there at the same time.
You're going to become a threat, or you are a threat to the business. The other, just flipping it around a little bit and looking at it from the employer perspective, actually it's a brilliant time to review the restrictive covenants, because I don't want to give you a law lecture, but there has to be consideration for the change, and the consideration at the point of promotion is the promotion. Whereas if you are looking at it from, oh, this individual's leaving and we don't think these restrictions are enforceable, then you would arguably have to give separate taxable consideration as part of the settlement. And of course, that's potentially a cost saving that you could have saved if it had been built into the process of reviewing it at the point of promotion. So there's sort of lots and lots of different benefits to reviewing things in a very kind of systematic, process-driven, sensible way. Okay, well, I don't think we've had any questions. We'll keep an eye on the chat just whilst I wrap up. So first of all, on behalf of the branch, a big thank you to Helena and Rianna for their time this afternoon, and indeed, I know all too well the preparation time that will have gone into this. And I'm very pleased that was not on my desk and on someone else's. So genuinely, a very big thank you to you both for your time and expertise and take on the cases and what you've run through this afternoon. As I say, I hope everybody has found it useful. Please do take a moment, and literally it is a moment, just to fill in the survey, give us your views on today, but also events in the future and what you'd like to see. As I say, there is an event tomorrow. We've had a bit of a jam-packed week this week for CIPD. I know some people had some difficulties and it was showing as sold out, but I've had the luxury of being able to solve that whilst Rianna and Helena have been talking. So if you have tried to book for tomorrow and found it was sold out, that's no longer the case. So please do sign up for that. We will be having our annual meeting. That is going to be, if memory serves me, around the topic of menopause in the workplace. So watch out for that. You can get details through, if you just follow our CIPD Eventbrite page, that will send you the details. You can register to get our newsletter as well. So we're going to finish slightly early, which I'm sure none of you will complain about. But as I say, thank you to Helen and Rianna, and a big thank you to you all for coming along. I hope you've enjoyed it, and I hope that we will see you at future events.
Thanks very much, everyone. Have a good evening.
Yeah, have a great evening.
Thank you. Thanks.